Chief Justice of Nigeria today, Justice Kayode Ariwoola, has bowed out after attaining the age of 70. And now, by procedure, Justice Kudirat Kekereekun has been proposed as the next in line to succeed Justice Kayode Ariwoola. And today, Justice Ariwoola has been assessing as he hands over, drop the baton, and exiting the judiciary, the bench, and making suggestion as to the way forward for the Nigerian judiciary. Of course, part of what Justice Ariwoola has said today is a need to lessen the burden on the apex court in Nigeria. And most of the cases that are being brought to the final court of the land, which is the Supreme Court, should have terminated in the lower court, and is making some suggestion as to how to unburden the highest members of the Nigerian bench. We'll be assessing and looking at some of the propositions made by the outgoing Chief Justice of Nigeria, Justice Kayode Ariwoola. Tonight, I'm being joined by a very senior lawyer, senior advocate of Nigeria, Mr. Kayode Adeluola, who joins us virtually from Lagos. Thank you so much, Leonard Stick, and thank you so much indeed for tonight. And what a day it has been. Now we're seeing the exiting of yet another senior member of the bench, Justice Kayode Ariwoola, and he's making some recommendation as to the way to go. What do you make of the very major recommendations that he made? It does look like the lamentation is coming from Justice Ariwoola as to the fact that the Supreme Court justices are overburdened with too much work, and some cases or some matters shouldn't be brought to the Supreme Court and should have terminated at lower courts. What are your views on some of those things that Justice Ariwoola said today?
Good evening. Thanks for having me. I'm not sure if you can hear me very clearly.
Yeah, I can hear you, Leonard Stick.
Congratulate my Lord Honorable Justice Kayode Ariwoola, who has just retired from the bench, and I wish him very happy retirement. I am aware that there have been issues concerning what we could do about the enormity of cases and appeals taken by the Supreme Court. Now, our justices clearly are overburdened, and it's not surprising that the retiree, were just recently retired, CJN has also come up with the issue about so many cases and appeals being heard by the Supreme Court, just like Honorable Justice Amina Oki pointed out when she was also delivering her valedictory speech. There's no doubt that we need to have reforms. Now, what reforms can we possibly have? I'm aware that the procedural rules for the Supreme Court have been done again, and that we're going to have the 2024 Supreme Court rules. Well, I haven't had the opportunity of going through those rules yet. But for the Constitution says that the Supreme Court will have the final say on matters which are civil and those which are also criminal in nature. Where someone has been convicted for murder, he must have an opportunity to be heard by the Supreme Court. But when we speak of civil cases or civil appeals, that is very wide, rather open-ended. So what we must ask ourselves, how may we curtail the cases that come from the Court of Appeal to the Supreme Court for their adjudication? Now let us ask ourselves, there are the way in the days of yore, matters which were heard in the palaces of the kings, matters relating to farmland, which essentially is real estate, matters relating to assets of estates, and matters which relate to personal relationships. And people left the presence of the king feeling satisfied. Also, in modern use, we have people who have decided that the commercial transactions will go before a single arbitrator or a panel of arbitrators, and whatever award is made by the arbitrators will bind the parties. In other words, it does not go on appeal. So why do we not have a situation where cases of certain nature, maybe in terms of the value, in terms of monetary value, are allowed to end at the court of appeal? Why don't we simply have that? I also know that there are cases which are taken to the Supreme Court, like Justice Aminaldo said when she was at the Supreme Court, they had a case involving, I think, goods that were owned by some people, and there was a dispute. And these cases went on as far as the Supreme Court, having 5 justices, noble lords, sitting to determine that. We should stop that. In other words, I think we should have a situation where we simply say, this matter should stop at the magistrate court or at the high court or at a court of appeal in the division where that matter has taken root. If a matter, for example, is about chieftaincy, a local affair in a local government in a state, why should it be the business of the Supreme Court? Those are matters we need to sift. Also, I think we should also determine if a matter comes before if an appeal is filed before the Supreme Court, it should go for some form of filtration. Filtration in the sense that some very skillful and knowledgeable junior lawyers can be impaneled, or some magistrates who have served for a certain length of time should be forwarded to be sent to the Supreme Court. And what they do is the back-end filtration. They will, at the end of the filtration, write to counsel and say, this matter which you have brought before us, unless you can demonstrate to us that there's a novel point which you want to canvass here, this sort of matter has been taken several times by the Supreme Court, and there are decisions of the Supreme Court which should guide you. If you insist, would allow you, but if a decision of the Supreme Court goes against you, you as counsel will need to bear the cost personally. I think some of our colleagues also will begin to look at things differently. We shouldn't come to the Supreme Court just to test knowledge. We shouldn't come to the Supreme Court just to test the waters or for academic exercises. That is my view. And I think also the high courts and the courts of appeal should be so fervent in their administration of justice that when they give judgments, even parties who want to appeal will think again.
Interesting that some of these recommendations are coming. And you see Supreme Court justices, when they're exiting the bench, they make some very significant comments. And you hardly will hear them, except when they are performing the duty of their offices. But I mean, with Justice Kayode, I wouldn't be the first, I won't perhaps be the last, when you are critical of the system and you're seeking judicial reforms and at the point when you are exited. But let's take a look at some of the things that Justice Adiwola said today. Part of it being that the burden is too much. The issues around what goes up to the very highest cadre of our court. For example, you remember the days of Justice Salami and how gradually cases like the governorship election cases now had to graduate and terminate at the Supreme Court. How can we achieve some kind of judicial reforms? Where will it come from? And there are those who will say Lagos State has given a whole lot of judicial reforms bequeathed to the rest of the courts in the land. And we see a whole lot of these things happening from Lagos State. We've seen a lot of those reforms. But in this day and time, some of these reforms that are being suggested by these justices, especially what Justice Adiwola said today, it will go down into the Constitution. But where do we start from? How do we begin these reforms?
Well, for us to have reforms, we must decide what we want to reform specifically. Because you see, we have all said there is a need for reforms. There's no doubt that we need reforms. But we need to have a conference of lawyers, of judges, of justices, and some members of the public, and decide what are those issues we can determine without necessarily coming to the Supreme Court. Look, the Supreme Court is a policy court. It's not a court for all manner of cases. So we need to go to the Constitution and say there that civil cases and criminal cases can come up to the Supreme Court, provided this, that, and the other. In other words, for example, a civil matter involving a car accident, a man hits somebody else's car, or you want to claim damages, and then what you're claiming is 200,000 naira, and you come before the Supreme Court because you're not satisfied with the High Court, you're not satisfied with the Court of Appeal. That shouldn't happen. And you know also, for example, at the magistrate court level, we have cases that they can handle because of the quantum of damages being claimed by the parties. For example, if it's a recovery of rent or recovery of accommodation, if it's not up to a certain level, a certain amount of money, you can come to the Court of Appeal. To the magistrate court. You don't have to go to the High Court. Such a policy should also be applicable to the Supreme Court. You don't come to the Supreme Court because, look, I'll tell you some story. About 5 years ago, somebody briefed me about a matter that was already pending before the Supreme Court. And what was this matter about? It was about a family of young men arguing about who was entitled to a particular room or rooms in a house in Jos. And I looked at that matter and I just thought to myself, how do I take this kind of appeal before the justice of the Supreme Court, asking them to determine that my client owns a room in a house in Jos? I turned down the appeal because I just thought in my mind that we cannot go before the Supreme Court and ask 5 justices to sit down to determine who owns a room. These are things that should clearly be allowed to truncate at the High Court level and not come even before the Court of Appeal. As regards the political matters, that's a different kettle of fish. When it comes to politics, we are a country of people who are politically aware. We are not even satisfied when the Supreme Court is fully empaneled, 7 justices. So it's something we need to be careful about. But then we have come to terms with the fact that there are some cases that terminate at the Court of Appeal. With time, people will get used to that. We must agree that if it's a governorship matter, whether you like it or not, once the tribunal has heard it and it has gone up to the Court of Appeal, full panel of the Court of Appeal should be satisfied. But then again, I will also admonish that we should have our elections well in advance of the time for swearing in, so that all cases will be heard and will be determined well before the date of swearing in. So our election should take place maybe 1 year before the swearing in, so that all matters coming before the courts, before the tribunals, will be heard and determined well in advance. So then there'll be no rush, there'll be no question of shutting people out because they've not filed papers within 21 days or within 30 days. But at the same time, our colleagues also must be able to advise, when I say our colleagues, I'm talking about lawyers this time, should be able to advise clients and say, this sort of matter should be taken off the list because we cannot go any further. Because if I go further with this case, with this appeal, I'm likely to be the one to be penalized for it. So those are some of the things we need to consider, but I think we need to have a conference of lawyers, judges, and members of the public to determine what are the cases that we think we should spare the justice of the Supreme Court from hearing. The magistrate court is almost beginning to be rendered redundant. Some of those, for example, our new CJN rose from the magistrate court to the High Court to the Court of Appeal before it became a justice of the Supreme Court, and today it's CJ. So there are people who are very knowledgeable at the magistrate court and who should be allowed to determine cases. And we must also consider another thing, which I've mentioned to some of my colleagues. We should have small claims courts. If your matter is only for 200,000 or for 2 million naira, go to the small claims court. Once that matter is determined there, accept it as the decision of the court. However, it means that all those who sit in those courts was a people of integrity, honor, and courage, such that when the decisions are given, you all go home satisfied, whether you're a loser or the winner, that justice has indeed and truly been dispensed.
Now, so look, when Justice Ariwoola was making reference to the burden and the number of cases that goes up to the Supreme Court, look at the numbers. A total of 1,124 cases were filed in the year, judicial year 2023-2024, legal year,
yes.
And which commenced in September 2023, ended in July 2024. Of these, there are 435 civil cases, 269 were civil motions, 219 were criminal cases, and 102 were criminal motions. The Justice Ariwoola said 89 of these were political appeals, which were filed at the apex court. Of course, that window was not an election year. We've just moved past an election period. But in that same period, there are only 248 judgments that were being delivered by the court. Don't forget, out of that were 1,124 cases, of which 248 judgments were delivered. 92 judgments in the civil and 81 judgments in the criminal appeals and 74 judgments in the political appeals. So if you look at how many of those cases were finalized, they are less than 40% of the entire cases that were filed within that legal year. It tells you how much of the burden of work that will be transferred into the next legal year. And that is why a lot of people complain about the Nigerian judicial system, how slow, sluggish the process, and how slow it could grind, and which delayed a whole lot of processes.
Yes, like as I said, let me first of all correct an impression. Those cases filed between 2023 and 2024 are not the cases which have been determined by the Supreme Court. The ones which have been determined are probably the political cases which have a deadline. Most of the cases filed in the 2023-2024 legal year are cases that will be heard maybe in another 5 years, 6 years, if they're lucky, or it could be more than that. So those are cases that have just simply want to take their cue. Now, let's go back to the High Court even before we come to the Supreme Court. In Lagos State, for example, the judges there sit from 10 to 1 o'clock or 2 o'clock. Why? Because they do not even have power. The generators are switched on and then switched off at a particular time. That's not healthy. That's not healthy at all. That's not a good thing. But the CJ has seen that the facilities he has, the finances available to him, cannot cope with having generators sit up for money till 4 p.m. In other words, the judges themselves need to have the facilities to work with. You cannot put judges under strain and tension and expect them to make make miracles out of nothing. These are people who are willing to work. I do not think you have ever seen the home or the office of a Supreme Court Justice, all littered with all manners of files. You have the records of proceedings that they must wade through. It is tedious. And these are only 21 people to determine 1,200 cases, appeals in a single year. But how do they expect them to perform optimally? How do you expect them to give judgments that will stand the test of time? In the past, the Supreme Court probably didn't have more than maybe 20 or 40 cases in a year. So they could sit down and write judgments that for a long time we continue to refer to. So what Justice Ariwoola simply has said is that there are many cases that have come before them that really shouldn't come before them. There are many cases that they have had to determine and they've had to look at, which are indeed and in truth a waste of their time. But I think people should be made to realize that you don't come to the Supreme Court because you have the right to do so. Well, then again, they have the right to do so, then they must come. So what should we do? We should look at the Constitution and determine whether some of these cases of appeals should actually find their way there. Otherwise, these noble laws will be burdened by cases that should not even come before the traditional ruler in their local governments. We must respect this space called the Supreme Court. But we must give them the facilities to work with.
Well, I mean, I'm just worried. Does the president, or who is a person who will bail the cat? Is a person who will take the lead in the judicial reforms that we are all praying for?
Very good question. We have senators, we have members of the House of Representatives. Many of them are lawyers. Even if they do not take the initiative, we as citizens should call upon our lawmakers and tell them we want these bills to be presented before the National Assembly. That is where laws are made. That is where we can ask for reform to our laws. Why are we beating about the bush? We shouldn't allow the senators and the House of Representatives members to simply sit down looking at just determining things that do not interest us. Let us tell them we want this bill so a lot of us who are listening to this discussion should simply call our senators and members of our House of Representatives and tell them we need a bill to be presented to curtail the cases that are unnecessary coming before the Supreme Court and the Court of Appeal. That is where we should start. Once the laws are passed, the executive will have to comply.
But I look at on the flip side. Justice Kekere might be sworn in on Friday. And what lies ahead of her is a huge, enormous job. But again, she will be working into a happier judiciary for her to lead, in the sense that 300% salary increase is some kind of cherry news for anyone who is to lead an other burden to be in the position of leadership in the Nigerian judiciary. But beyond the money, what other incentives do you think are important now? How happy should Justice Kekere would be, or how difficult would our job be?
Well, Justice Kekere clearly is somebody whom I know as a judge sitting over there, and I see her, and I know that she's capable. I have no doubts in my mind that she has her plans as CJN. I mean, she wasn't caught unawares. She knew that by Honorable Justice Kaide Ariwola will be retiring. So I'm sure she must have been preparing her mind and perhaps, in fact, preparing her desk to get onto this job. I know that once she starts to preside at the Supreme Court, a lot of people will understand what policies and what she stands for. That's not to say that her colleagues don't even know her yet. But see, we know that the Supreme Court is going to work very hard. I have no doubts in my mind. And I described it just yesterday as, a judge wants the name and the courage to dispense justice. But they must make the facilities available to these justices. Do you know that some of the justices who were appointed recently, I don't know if they have left, until a few months ago, didn't have accommodation. They were given some suites in some guest houses. How do you accommodate justices of Supreme Court like that? It's not tidy. You must give them the facilities to work with. And you must attach to them people who are going to do the research work for them. People who also have honor and integrity. Young people. That's what obtains other parts of the world. Let them have people they can call upon to do this part of the work for them, but they write the judgments by themselves. And of course, we need to start imbibing the culture of using information technology in our courtrooms. So the Supreme Court should stop having judges flipping through so many pages and let briefs of argument be sent to them electronically so they can carry their laptops without having to load heavy files into their cars every evening when they're going home. Let them also be seen as people who are working in a modern age. I know that Justice Kekere will listen to a lot of advice coming from well-intentioned people, and we should all do this. Journalists, lawyers, members of the public, and other judges of different courts should give her advice. But again, as I said yesterday, we need to stay clear of judges' chambers and their homes, allow them to do their work, and allow them to exercise their discretion when cases come before them, and so that we don't have them being poured over by people who simply want favors. They're not people who should dispense favors. They're people who should dispense justice.
So now we've been having issues. I think the Constitution provides that the Supreme Court will be consisted of not more than 21 justices, isn't it? Now Justice Ariwoola is bowing out. That means there will be a deficit, isn't it? So for several years, we never had it completed. The Supreme Court was never completed for several years. But now, as Justice Ariwoola is bowing out, it means that there will be that deficit. They've been crying about and lamenting the burden on the justices that are available. Would there be an urgent need to replace Justice Ariwoola?
Yes. The answer is yes. We have rightly come to the point where we now have 21 justices. If one leaves, we should simply replace the one who has left. If Justice Ariwoola has left and was occupying a seat of a certain region of the country, let another justice of the Court of Appeal take his place. Let the work go on. Let's not burden those who are there. 21 justices can have 3 panels sitting as against 1, right before we had the new justices who were appointed recently. So let us have speedy dispensation of justice by having more justices on the Court of Appeal, at the Supreme Court. So if Justice Justice Ariwoola has left now, let us find someone who will take his place as quickly as possible.
I'm not sure we even have up to 15, I don't know, maybe like 10 or 11. There are those times that there were those who were suggesting that very eminent members of the bar in the academia, in the civil society, should be appointed as Supreme Court justices. Could that be a way, a low-hanging fruit for us to fill those empty benches in the Supreme Court?
Well, in some parts of the world, Queen's Counsel are appointed to the bench. Things happen in different parts of the world for different reasons. My attitude is, if you knew you wanted to become a judge, you should have gone to the judiciary from day one. You're a senior advocate, you want to become a justice of the Supreme Court, it's okay. But then there are people who are the Court of Appeal. It's a career that they have pursued all their lives. So it's time for them to get to the Supreme Court and you say, no, it's not your turn. I'm coming from the bar. It's something we should think about very carefully. If I was a Court of Appeal justice, and then you bring somebody from outside to become Supreme Court justice, you see, you don't want to make people unhappy with their work. They are people who have worked tirelessly from maybe the magistracy to the High Court and then Court of Appeal. They are hoping and praying to become justice of the Supreme Court. Then you bring somebody from somewhere else. It's something we need to think about. I mean, I have no clear answer to that, but I think those who are the Court of Appeal who are also hoping and praying to become justice of the Supreme Court should be given a chance. And that's my attitude towards that. And honestly, if you want to become a judge, I think you should go to the Court of Appeal. You should go to the High Court. But then again, we've had 2 instances I can remember off the top. Honorable Justice Nnamani went straight to the Supreme Court from the bar. Also, Professor Elias came straight as Dean of the Faculty of Law in the University of Lagos, at the University of Lagos to become CJN. And I recall that I had a comment by some of those who sat with that, well, if Professor Elias is coming to become CJN, we don't mind. He was exceptionally brilliant even when we were in school, so we don't mind him being our boss here. So it's something you need to think about very carefully.
Mr. Kayode Aderola, not Justice Kayode.
No.
It's the Justice Kayode Ariwoola. But we've been speaking with Mr. Kayode Aderola. Senior Advocate of Nigeria, thank you so much indeed for your time tonight. I appreciate your thoughts.
Thank you very much for having me. I'm grateful.